So our final plenary session is entitled Prosecutor-Initiated Resentencing, a new tool for expanding justice. This is a very interesting panel, and I don't say that just because I'm a prosecutor. I say that because this is a really different way of looking at long prison sentences, because it's prosecutor-led. And I'm really excited for all of you to hear what Hillary Blout of For the People has to say. She's put together an amazing panel, and I think that everybody will be very, very intrigued by what she has to say, because I have heard from other presentations of the same panel that it was exceptional. NDAA had them very, very recently, and the feedback was very positive. So, and that's from us prosecutors, and we're a jaded bunch. So, without further ado, Hillary Blout.
Thank you. All right, great. Well, thank you, everybody. I know it's towards the end of the day, and people are ready to get to happy hour, but we appreciate you guys coming to participate in our panel. So I am Hillary Blout. I'm the founder and the executive director of an organization called For the People. And what we are planning to do with the time that we have with you is we're going to start just with a high-level overview before we get into the conversation. I'm going to share with you just a bit about how the law became so, how it has been working in practice, and then we're going to turn to our panelists so that you can hear directly from them, from their perspectives, from the work that they do, about how this work really fits in with the work that they're doing. And I think that what we've heard through a lot of the speakers that have been here, and we all know this, that we are all eager to find areas where we can work together. We're eager to find things that can be solutions for all, things where we can find alignment and not divisiveness. And I think as public servants, for those that are prosecutors and defense attorneys, it is an adversarial system, but we think we have discovered an area where we can agree to disagree on a lot of things, but we also can come together and find common ground around something as important as getting people out of prison that simply don't need to be there. And kind of across the aisle, across the states, in rural and urban environments, and progressive and conservative prosecutors, it really is something that we have found that is basically broad agreement that it's the right thing to do. And it started out as this concept, but I'll tell you a little bit about how it evolved, and then we'll hear from our panelists. I'm not sure where to click here. Tech, friends. Thanks. Okay, well, you know who I am, and you will soon be able to hear from the other panelists that are here. Again, already kind of illustrating for you different folks from different stripes coming together on something that we found that really is cutting across a lot of the things that maybe might have divided us previously. And so we're going to hear from Dwayne Woodley. He is the second in command in San Diego, the 5th largest county in the country. And he has been doing this work now for 3 years. It was actually the first adopter in California to do this work. You're going to hear from Nazgul, who you probably have already know her name. If you haven't, you should write it down. She has contributed so much to the field around research and findings on excessive sentences, prison sentences, and different types of reform. And then finally we'll hear from Frank, who is the Director of Government and Legislative Affairs for the National DAs Association. So we're gonna, before we hear from them, okay. Okay, great, perfect. Thank you. Okay, So just level set, these are numbers that you're probably all familiar with because you have been in the criminal justice space, even if it's been 5 minutes or 15 years, you know that these numbers have been repeatedly been coming up. One is that we have nearly 2 million people who are currently incarcerated across the country. That for each person that is in prison, we're spending a lot of money. California specifically is over $100,000 per year per person to be incarcerated. And it's about $80 billion that we're spending as a country to have people incarcerated and also have them on different forms of correctional control. And so this was kind of the beginning of this question as we're all talking about resources, talking about being strapped for resources, the question becoming, is this the best way to spend our dollars? And if there are people that could be safely released, is there any way to spend this money differently? I love this quote, and not just because, I don't know if Linda's here, not just because this is from the standards, but this has been something that I have been saying for years, which I have believed in since I was a prosecutor and believe to this day. What is asked of us as prosecutors? And I think a lot of us, when we went to law school, we didn't know that we were going to be asked to be social workers and problem solvers in this way, but things are changing, and this is what's being asked of us. And so a lot of prosecutors are really leaning into this directive, which is that we're beyond case processors. We are being asked to be problem solvers. We're being asked to respond and seek to reform the system where we do come across inadequacies and injustices, and we're asked to be responsive to what community is asking of us. And so this is, again, really where some of this thinking around where do prosecutors fit in this question around people that are in prison that don't need to be there. If you have been practicing, you as a prosecutor or a defense attorney, you know that while there have been innovations that are happening on the front end, oftentimes prosecutors have not typically been very involved on the back end. Lots of innovations around diversion and drug court and adult court and so forth, but not a lot of activity on the back end of prosecutors, but it's not unprecedented, right? So prosecutors have been involved in conviction integrity units, have been looking back to see if convictions that have been handed down in their offices can still stand, that they can stand with integrity. So this looking back is not new, but I want to name this because when I first began, I left the DA's office and thought I would go back, do a little policy and go back. But one of the things that we had begun is talking to offices around conviction integrity and thought we would support them in strengthening their units. And what we heard time and time again is that what we need help with is that we have cases that are coming across our desk. It's not about innocence, the person is guilty, but the sentence is very long. And the sentence is longer than what we would give today. And we're reading about letters from correctional officers and people that know this incarcerated person well. And after the last 10, 15, 20 years, it appears that this person is no longer a threat to public safety. We can't do anything about this. So this is what we heard, and this was really how the problem/solution was born for us in California. We talked to prosecutors up and down the state, and conservative, progressive, urban, rural, everybody really leaning into conversations. I went back to people that were the hardest hitting DAs in my own office and said, do you think that there's people in prison that don't need to be there? If you knew of somebody that could be safely released, would you want them to be reunited with their family? And everybody said yes. That was the response from most people that we talked to. One of the things that we were told, though, because prosecutors had been labeled as being against all kinds of reforms, and one of the things that prosecutors said to us was, it's not we're against all reforms, we're against reforms that don't include victims. We don't like the way that victims are notified as an afterthought when a decision is being made about somebody being released. And that they wanted something where they could be in the driver's seat and be able to take control of decisions that are being made about their counties, about their communities. Because when somebody is resentenced and released, they're coming back to that prosecutor's county. And that was something that they wanted. So that was how the idea began in California, prosecutor-initiated resentencing. So in 2018, I drafted and secured this law It passed unanimously in California without any opposition, and basically what it does is it gives prosecutors the ability to make a recommendation to the court that a person can be and should be resentenced. When that recommendation is done, the court is then vested with jurisdiction to be able to resentence a person as if they had not been sentenced before. The law is pretty basic. It has 5 components to it. It is discretionary, so prosecutors can opt in or opt out of looking back at cases based on their constituents and their own resources. There are no exclusions or carve-outs, so prosecutors are deciding the kinds of cases, the volume of cases that they are going to look at. The court authority is that the court will make the final decision if the person can, in fact, be safely released. Victims are required to be notified and consulted, and obviously because prosecutors are driving this, they are taken into, it's not just a notification process, but it's a consultation process, which we'll get into talking to Dwayne a bit about how that actually works in practice. And then the sentence has to be lesser and it has to be legal. Some initial questions were, does this mean the sentence can go up? No, the sentence cannot go up. It has to be a downward departure. Lesser, legal, and then the court will consider post-conviction factors such as how long has a person been in, how old were they at the time of the offense, and ultimately whether public safety warrants this person being released or resentenced. I will go through this very quickly. We have a guide that goes into these details a little bit more so we can jump to hearing from our panelists, but these are essentially the steps that have been taken in most of the jurisdictions that are using prosecutor-initiated resentencing or even using another mechanism. I should add that, before this law was passed, there have been other mechanisms that prosecutors were using. Sometimes they were legal workarounds, sometimes they were legal fictions, but there have been some laws that have been passed where prosecutors have advanced cases. But the PIR work has basically looked like this. Offices identify senior, usually felony trial attorneys to guide the work. They build partnerships, and we help to forge these with the Department of Corrections so that they can get prison data and prison records, hear from correctional staff about people who are incarcerated. Usually they're getting some training, typically that's from us, about how this all works and how to get their data and how to get their records. They are analyzing prison data to identify people that and groups of cases that they want to look at, setting criteria and making that known externally and internally to deal with some of the kind of inbound requests that are coming, so people know the kinds of cases that office is beginning with in their review. And then directly engaging with incarcerated people and asking for a series of documents, journey letters, remorse letters, accountability statements, reentry plans, and so forth, so that the prosecutor can get a real clear sense of what it would look like if this person was resentenced. And then reviewing files, selecting candidates, consulting victims, as I mentioned, motion writing, which we all know about, supporting reentry, and then ultimately reuniting families and reuniting communities. These are just a couple of the people that have been resentenced and released just in California. And by and large, what we have found is that these are people that are returning home to their communities to take care of children, take care of elderly parents, work 1, 2, 3 jobs. And so one of the things that has been a bit surprising to all of us in this work is that we're finding that this is actually not just the right thing to do for most prosecutors, but it is having a public safety benefit. People that are coming home are deciding to use their time as credible messengers and work with young people to interrupt future cycles of crime, right? Talking about the choices that the person made and trying to prevent others from making those kinds of choices. They're working as substance abuse counselors, they're volunteering at homeless shelters, and the list goes on. So we're seeing this other benefit that we didn't really consider at the outset. Additionally, what we have heard time and time again from everybody on this screen, that when they learned that their case was being considered, they immediately shared that out, and other incarcerated people said, well, what did you do? How did you get this? What's happening? Pulled out their pencils and started taking notes. And these folks would say to them, well, I took classes, I completed my substance abuse course, I got my certificate in anger management, I made different choices. And so we hear that time and time again from people that are being released, and also when we go inside the prison, that they're well aware of that the DAs are paying attention to the work that they're doing, that there is a way in which prosecutors care about the hard work that they're putting in, and they want to be responsive to those efforts in the prisons. I will just close out on what is happening nationally. As I mentioned, in 2019, this law went into effect in California, and since then the law has been passed in 4 other states. And so it exists now in Illinois, Louisiana, Washington, and Oregon. And then it has also been proposed in 7 other places, just to give you a sense of the kind of interest and movement and appetite for laws like this across the country. And last but not least, as I mentioned, 5 states now have this law since 2019. About 500 people have now been resentenced, and this has been at the direction or in agreement by a prosecutor making the determination that a person could be safely released. And we estimate that about 5,000 years have been eliminated from people's sentences, and this is, we believe, a conservative number. So this is a high level kind of what has been happening, how this started. We have a guide that you can download from our website that tells you a little bit more about how this works and how it can work in other states. And I will close out there, and I want to invite Nazgul to talk a bit with you about thematically, this is what we've been doing in California and moving into other states, but I want to turn it to her to talk a little bit about what has been happening kind of across the board in the research world around people and age and sentences and data, and what you see up here around some of the themes of why we have been hearing more about Second Look. So with that, I will turn it to Nazgul.
Thank you so much.
And I can change, or you can,
Okay,
whatever you want.
yeah.
Okay, I'll do this for you.
So I think one of the reasons Hillary invited me to this panel, and I'm so excited to be here, is that we thought if I could share with you some charts, it would really jazz up our Friday afternoon together. So that's part of my purpose here. So if I could just show you the first chart here. This is something I show a lot of different audiences with 2 goals. I show this to sort of general public who's interested in criminal justice issues in order to dispel a couple of broad myths. I think that one of the very common myths that people hold about the criminal justice system is that they're just, our system is just full of people with convictions for marijuana, right? And so I'd like for people to recognize that that's not the case, and that if we were to legalize cannabis in the country, we would still have a large number of people incarcerated. And so if we really want to think about why do we have such a high incarceration rate, we need to really look more closely about what are the criminal convictions that people have. And another reason I would use this chart is for audiences like yourselves who are experts, criminal justice practitioners, who have quite a bit of expertise on the law, on handling cases, but you might not be as familiar with the broader data on what's going on nationally or within your state in terms of convictions and how much time people are serving. And so I'm hoping that this will have some useful information here for you. So this is a chart that breaks down the prison population nationally by offense type. And so each line shows you people, the top line is the number of people in prison with a violent conviction. And you can see that's the highest line, that's the largest population that's incarcerated. And so that's roughly half the prison population is serving time for a violent conviction. And then the other lines, the light green one there is the population that has a drug conviction as their most serious offense. And then the lowest line there towards the end is property crimes, people that are imprisoned with the property convictions, with a property conviction. And so you can see all of the lines going up, but then the drug and property lines beginning to come down in the past decade or so. That's the most progress that we've made in terms of scaling back the prison population, people in prison with nonviolent convictions. And that's not much of a surprise, right? When we think about the sort of broad public sentiment and political discourse, most of the focus has been on the population that's incarcerated with a nonviolent offense. And yet the number of people in prison with a violent crime conviction has only declined by 2% in recent years. And that's really notable because if I were to also show you violent crime trends in the country, you would see that they dramatically increased starting in the 60s, during the 70s, 80s, until the 90s, and then dramatically declined, such that before we got to the pandemic, violent crime rates, homicide rates, were about half the level that they were at in the 1990s. And of course, they've begun to climb in recent years, dramatically in the case of homicides. But so that's important to realize because I think when you think about those two trends together and you only look at the United States, you might think, well, we've been increasing the number of people in prison for a violent offense, and maybe that's helped to contribute to reducing the violent crime rate. But if you look more broadly and you look at, researchers have done this for about 24 countries, and they've shown that the United States is part of a broader global pattern of violent crime rates going up and coming down, but we're exceptional in dramatically increasing incarceration levels and continuing to increase them even while violent crime rates have come down. So I think that's one of the best indicators for me that we actually don't need to imprison so many people for a violent conviction in order to have the level of safety that we've achieved and in order to continue to achieve more. And part of the reason this top line has increased so much is because the duration of time people spend in prison has dramatically increased over time. So by one measure, for example, that I've looked at recently, we have more than half the prison population overall nationwide is serving a sentence of 10 years or longer. And that's a really dramatic sentence, and it's really notable because criminologists have shown that 10 years, that 10-year mark is really significant because a lot of people age out of criminal activity after 10 years. Criminal careers typically don't last beyond 10 years. Alex Piquero, for example, who leads the Bureau of Justice Statistics now, he's a notable criminologist, has said most criminal careers end within 10 years. And so that's why it's really important to think about these lengthy sentences, in particular, even for people that have violent convictions, ranging from offenses including certain types of burglary, robbery, but also the most serious crimes such as sexual offenses and homicide. So if I could show the next slide. Here is another way of looking at that sort of strengthens this argument that I'm trying to make, that people generally age out of criminal activity, including for the most serious crimes. So these are some classic age crime curves, and it shows the bar at the bottom shows the line at the bottom, that the x-axis is age, and then the y-axis is the frequency at which people are arrested. The chart on the left is murder, and the chart on the right is robbery. And you can see that the peak age of arrest levels is in the early 20s. That's when most people are arrested for these kinds of crimes, and then the line begins a dramatic decline. So very few people are arrested for these crimes by the time you look at people in their 40s, 50s, beyond. So you might think, well, maybe part of the reason for this is because when people do commit these crimes and we arrest them, we lock them up and they're not reoffending, right? And that's part of the explanation. But that's only part of the explanation because you're probably familiar with clearance rates for homicide, clearance rates for sexual offenses, low levels of reporting for these crimes. And so what we know is that a lot of people are committing these kinds of crimes, getting away with it, and yet even despite that, and even when you look at the population that is incarcerated for these crimes, when they are released after serving sentences of a decade, 2 decades, or 3 decades, they have some of the lowest recidivism rates, and that's what you would expect from these charts, right? Once people get to be in their 40s, 50s, beyond, they're incredibly unlikely to reoffend. And so then the question becomes, why would we continue to incarcerate them? Is the objective public safety? These kinds of evidence suggest that we're not advancing public safety by continuing to incarcerate them. Is the objective to serve the needs of victims and survivors? In some cases, we know that these individuals support resentencing and release for these populations. And so this really raises questions of why do we have extreme sentencing, and what other more effective investments could we be making in public safety instead of continuing to incarcerate people for extremely lengthy periods of time. So I'll stop there for now.
Oh, thank you. That's a perfect segue. So it's, everyone can hear me, right? Can you hear me? Okay. So it's with that backdrop, right? So there's stats and there's data around what we know about people who are incarcerated and trends. And then there's the being a prosecutor in an office who has an obligation to their community and also to victims. And so I will turn to you, because that's what you have to deal with, is balancing those two things, hearing what you've heard, and then also trying to do your job. And so I would love for you to just tell us what it has been like to implement this work in your office. It is a huge office. It is conservative, it is not one of the progressive offices that are out there. And so can you speak to what that has been like to implement this in San Diego?
Yes, so we have over 1,000 employees, over 335 DAs in our office, pretty large office. And we started this journey with, as DAs, you always, you get community requests to take a look at cases. And after Hillary got this legislation passed, we took a look at a case that was requested by a prominent community member, and this gentleman was doing 50 to life, and he had committed those residential burglaries. So I took the case, I met with the community member, I met with his family, found out he had tons of family support, people in the community that were going to look out for him. I then went back and took a look at his C-file, prison record, saw that he had been going to substance abuse classes, had been a mentor in the prison, a mentor at a time for young folks that were in the prison who, at a time when he had no idea that he had any opportunity to get out of prison. He was an older gentleman at the time, but he was willing to help folks in prison and help young folks turn their lives around and tell them to do the right thing in a program. And so then I went back and I took a look at cases in our office for the last 6 years with similar prior records as his and similar offenses that he had. And I found out that we had not sentenced anyone to a life term for a similar offense as his. And that included both jury trial cases as well as the cases that we had disposed of. And so clearly we weren't sending people to prison for indeterminate terms for the similar offense that he had. So we decided to utilize this law to resentence him, and we presented the case to the court, and the court agreed based on everything that we presented, and the court gave him credit for time served after serving 17, 18 years in prison. And that was the beginning of our journey in resentencing. And so with that success, which we believed it was success at the time, we just started to embark on doing more of these cases. And as we took a look at more of the cases, more people in prison for a similar offense, we started to realize that, did they really need to do 50 years to life in prison for that? Or could they have rehabilitated themselves earlier? Did they deserve another chance to get back to reunite themselves with their communities? And so a sentence like that, we were not sentencing people that way today. This is a person who had rehabilitated himself after 17 years in prison, still had family support, had community support. Why not give that person a chance to reunite with his community? And so as we started to look at more cases and saw more cases like this gentleman, it only motivated us as an office to do more. And so We now have created a separate sentence review unit in our office. Unfortunately, we have the resources to do that. And we are actively put this information on our website, put links to portals for people that want to apply, and we have about 195 pending requests currently in our office. So we include the victims in our process. It's very important. We wait until the end of the process. We want to make sure that this is a person, after we've done our due diligence, is someone that we would think is an appropriate person to resentence before we contact the victims. Once we contact them, we have we do it in a trauma-informed way, and obviously we explain everything that the person has done and why we are recommending this person be resentenced. And we've had very much success with all of our victims who have agreed with us with the decision that we're making. I think we've only had one victim who opposed that request. And it's been very successful so far. And the one thing I will tell you that I'm very proud of is, as we do more and more of these in the office, there's a lot of resistance at the beginning. A lot of people thought that we were implying that they had done something wrong by the way the case was originally handled, and we try to tell them all the time that that's not the case. What it is just giving people a second chance. And as more of our DAs are looking at these cases and reviewing them, they're starting to see for themselves that these sentences that were handed down 20 years ago were so excessive compared to what we are doing today and what is the appropriate amount of time for accountability. But it's important that we, get people back in their community and back with their families. And I personally, everyone that we resentence, I invite them back to my office with their families, and I sit down with them and I talk to them about, you got to pay it forward. Go back in your communities and help other people making that transition back in the community, because there's someone else in prison that there's going to want an opportunity to be resentenced, and your behavior is going to reflect on whether or not we continue to have success in this process. And so that's the best thing for me is actually sitting down with them, watching them interact with their families, seeing the light in their eyes again about being reunited. And I think that's motivated us to continue with this process and continue to move forward.
And that's California. And I think we hear a lot sometimes that this is just some crazy thing that Californians are doing. It's just not something that would happen outside of California. As we showed you on the map, it is in fact happening outside California. And one of the things that we talked about early on, and one of the things that was really important about this work, was that we really needed this not to be politicized. It really needs to be the function of the prosecutor. It's their job. Was the sentence just at the time? Okay, fine. Is it just today? If it's not, the prosecutor has an obligation to do something about that. And so I want to bring Frank into the conversation and just ask you when you first heard about this and what the members said from the National DAs Association, and how it's been received from the folks that you're talking with.
Well, this will be the least surprising thing you hear this afternoon. The prosecutors were skeptical. And so working through that process and really going through what Dwayne went through, we were able to really understand this from a holistic level. And everything we've talked about today, and I know you say politics is something you want to take out of it, but the reality is, and you know it, speaking in the ABA today about violent crime and the challenges we're seeing in public safety, politics does matter here. And so this needed to not just be a progressive thing or a conservative thing or a moderate middle of the road. It needed to be for everybody. And what we've discovered is that improving community trust, improving community safety go hand in hand. And this was one of those unique efforts that allowed prosecutors to drive the car, the ship, the boat, whatever your metaphor is, on actually leading in public safety. So when we brought it to our members, and for a good context of NDAA, we have 5,000 prosecutors across all 50 states, each of the US territories, and each of the Canadian territories. So we're a unique group, and getting to consensus is really easy, as you can imagine. We do it all the time. In reality, it's a very difficult challenge, trying to get all of the different folks on the same page. And something that really united the membership was the first understanding that prosecutors get to lead here. Many times in criminal justice reform over the last few years, there are things we're very supportive of as an association, as a membership, and as a profession. But oftentimes we were taking a back seat, or we were brought in at some point later in the process. This is unique in that prosecutors are the frontline leaders of it. And so from that perspective of our membership, we took it as is this something that's going to improve the profession? Well, as you've already heard, the answer is yes. Is it something that's going to improve public safety? Yes. because we're creating the building blocks, both in prisons and then in the communities, that establish not just trust in our offices and our members, but also trust in the broader system. And I think it was unique in the sense that it wasn't just a judge allowed this or we changed the sentencing laws. No, a prosecutor stood there with the families of a victim and the families of a former offender or someone who admitted their guilt. And we're saying we're all going to move forward in a positive direction. The minute we were able to present that, and I know this sounds high level and kumbaya, but the reality is we're on the precipice of a very difficult environment, and crime, public safety, and a lot of the work I do legislatively. We're in a very difficult environment. One of the fears we have is that we're going to roll back a lot of the positive things that we've done over the last 5 years to improve public safety, but also to improve the criminal justice system. This feels like an effort that can keep the ball moving forward. That we can say, look, law enforcement is here with you. We are at the table. We are taking a very strenuous process, right? It is, and we'll talk a little bit, I'm sure, about resources, but it is A to Z process involving both the prosecutor, the victim, the defense counsel, the offender, the person who may be freed from this, etc. But in the end of the day, it is an important step in making sure that we are both addressing public safety, but not looking at the criminal justice system as something as a mistake for what we've done the last 5 years and reducing the prison populations that we have and continuing to go down that road.
Right. And just kind of turning to Nazgul, just in the sort of theme of skepticism, I know that equally there was some skepticism from the defense community and from the advocacy community that are prosecutors actually going to do this? And is this actually going to be something that is useful? And so I would love to just hear from you, Nazgul, why, under the umbrella of Second Look, why this is something that you are supportive of, and how you feel this fits in with the broader work that you're doing.
Yeah, I think that, I think of Second Look and post-conviction relief pretty broadly, and so that includes when there is sentencing reform that includes a retroactive element, or court ruling that includes a retroactive element, or petitioner-led resentencing where people can directly petition to courts and ask for their sentences to be revisited. Also compassionate release, medical parole becoming reinvigorated beyond what it is currently, clemency by the executive, beefing up parole, making it more meaningful, making parole hearings happen earlier and making them more meaningful than they have been in the past. All of that I think of as part of the umbrella of approaches that take a second look at sentences. And I love the way that you framed it as looking at sentences that wouldn't have been as punitive now if they were handed down, but also looking at sentences where they may have where the individual may receive the same sentence now, but a period of time has passed and we have a lot more information about this individual to consider whether or not that sentence is still appropriate for them. So for both of those kinds of reasons. And I think one of the ways that prosecutor-initiated resentencing is incredibly valuable is because in jurisdictions where these other kinds of second look might not be possible, it creates the possibility for there to be justice for people who don't have other avenues, but also creates success stories of people who are released, and we can see that when they come back to their families and to their communities, they're able to contribute in these places. And that helps, I think, to strengthen the muscle for broader support of reforms. And it's also, I really appreciated your point, Frank, about contributing to legitimacy of the criminal justice system and showing that these are not issues that only defense attorneys care about, only family members of the person who's incarcerated care about, but also in some situations we have victims and survivors who are uncomfortable with the person continuing to be incarcerated, who feel that that is not a just outcome, but there, in many jurisdictions, there's just no remedy available for them. So I think those are some of the values.
Okay, right. And so I want to bring it back to you, Dwayne. what we hear all the time from offices, and before there was funding, California did make an investment into a pilot program. So $18 million came to a pilot program for California for 9 counties to be able to do this work. And the money went to the prosecuting agency, the public defender office, and then also money was given to prosecutors to be able to support reentry services from a local reentry provider. So there's been resources. However, I want to talk about what you did before there was money, because before there was any funding, the funding just came in at the end of just recently, actually. But there were offices that were able to do this work, and not to undermine what offices feel about there not enough resources. But I would like to just hear from you, what were the ways in which you were able to kind of have some creativity to be able to do this work? Because it's volume intensive, and we weren't working together before. We've helped a bit, but can you talk a little bit about how you did that, and maybe how other offices could potentially do this without state funding?
Well, we were fortunate enough to have, one of the things that is really important in this process is the reentry process, right? Making sure that they have a good reentry plan, making sure they have community support, housing, all those things are relevant in that reentry plan. And fortunately for us, we had a person on our staff who we assigned to be our reentry coordinator for the potential candidates that we were going to consider resentencing. And he would go out to the prison and make sure they all had their plans in place, or we could connect them with people in the community that could provide them, whether it's apprentice services or make sure they had substance abuse counseling set up for them before they entered the community. So
This is Robert.
This is Robert, right?
Right, it's a Robert who's
Right.
formerly incarcerated.
Formerly incarcerated.
And also would say no to some cases too.
Yes, he would
Right,
say, he
right.
definitely would
Like,
say
this
no.
is- Don't
from-
believe what you're reading.
From
Right.
his conversations
Right.
with them in the prison, he would
Right.
tell us, no, this is not a good candidate.
Right.
And so that was really helpful to us, because that helped us be more successful in the people that we chose, but it
Okay.
also, it's part of our obligation to the community and public safety is make sure that we're making the right decisions, and we're not just doing this for every case that comes before us, and that we're making the right decisions for the right people. And so that's something that we had in place long before the funding came. But since then, we are one of the partner counties for the people for this project. It's been helpful, and I think as the community has seen us doing this work, now there are more people willing to engage in the reentry work in the community, and we now have a lot more resources in the community that we can turn to help put these plans in place.
That's great, that's great. So we promised that we would leave, I have more questions to ask of the group, but I always go over and don't leave enough time for questions. So we can open it up for any questions from the audience, or I can just continue with the questions that I have. Yes?
I had a question. First of all, thank you for the panel, and it's the first really exciting thing I've heard, especially people formerly incarcerated, people advocating and helping other people seems like kind of the missing piece to a lot of these convergent programs, so I love that. The one question that's been bothering me listening to all of them is there's a lot of emphasis on people being returned to the community when they have community support and family willing to take them in. And I just wonder if there's an issue of fairness for people not getting a reduced sentence because they don't have family or financial resources to take them in. And I was thinking about that listening to the white collar bit earlier today. Everybody has resources. What about the people who don't?
Can you take that?
Well, I mean, I think that there are a lot of resources in the community available. And so that's why one of the things that it's important for us, and why we have a person on our staff that can connect those folks to resources to make sure they're set up. Now, sometimes these plans take a while. It's not something that happens overnight. So they do have the ability to reconnect with community services and make sure it's all set up before we even refer the case back to the court for resentencing. So sometimes those do take longer than probably the client would like it to take, but we have to do that in order to make sure that we are maintaining the trust of the community to keep doing this, that we're going to be successful. And so we're utilizing every resource possible in our community.
And there's also been efforts, we're lucky to have partnerships with different, statewide and national organizations. Center for Employment Opportunity is one of them. We've partnered with them so that people that are considered for release are able to get cash assistance and a whole set of supports when the DA has made the determination for somebody to be released. That can address some of those gaps. But the reentry framework, I think, across the country is obviously it's under-resourced, but there are ways that a lot of offices are trying to fill some of those gaps, specifically for what you just named. Yeah. Yes.
I have a question for Frank. Years ago, when I was chairing criminal justice section, I went to NDAA. We had a series of resolutions. We got a lot of support from the prosecutors once they understood that what we were bringing forward. But on this is skeptical is what I would have guessed the prosecutors would be about this. I love the way you presented it, but let me ask you what I think is a hard question. When I went to do the presentation, I was doing it to the board, and that was about 75 people sitting around this huge table, and we got almost unanimous votes on these resolutions, but there were a couple of hardcore holdouts who wanted to make clear that they weren't about to do reform. I'm just curious, do you have a sense of roughly the percentage of prosecutors who would like to see this available to their offices, who would support legislation that would allow them to do this? Because to me, that's really an important thing.
It's a fantastic question, and that board has only grown from 75 to 100, just to make things more difficult on us and on the work that I do. But I will say it's actually a good thing, and one of I kind of will give you an answer that I kind of already gave, but I think is important to the context of this. Having this be prosecutor-led is what has distinguished it, even as we are going internally through our own process of how we respond to the ongoing, public safety crisis we're currently in. And I think part of the struggle from our membership even back then and now, when you talk to our members, is we are tangentially involved. When I say that, meaning that when you do something like mandatory minimum reform, fantastic, some of our members will support certain provisions versus others. Another thing that we haven't touched on, which is exclusions, in certain spaces of sentencing reform, we're okay on X offense, but maybe not on Y offense. Here it's a little bit different because that decision and that process is going through a prosecutor's office, likely, as Dwayne laid out, through a set unit, then up to the elected. And then this is the part of it that's important, and I think gets left out a lot, the accountability that we as prosecutors have, and our members have, and our elected and appointeds have to the public. So if you do make a determination and there is a subsequent reoffense, it's not just a question of were you too progressive or too conservative. It's a question of how do you explain that to the community. And so the feeling I think internally from our members was, well, we yes, hold the cards here a little bit more than we do in other situations, but we also do have an accountability that will not change and has only been heightened under the scrutiny of the last 2 years. And I think that actually, funny enough, it's counterintuitive, but brought a lot of our members on board to say, okay, we still want to be a part of this reform movement. We still also need to be conscious of the violent crime surge we're seeing. But this gives us the opportunity to drive it with that accountability still out there. And we've seen that through elections, right? And so that piece being there was really sold a lot of our membership. So I can't give you a full number, and I can't tell you we've talked to every DA, but I will tell you across my 13-person legislative committee and across our executive board, it was unanimously supported, and the concept itself is something we're continuing to grow on.
Ms. Gould, has anybody asked you to, on the defense side anyway, asked you to provide these kind of statistics to the court at the time of sentencing? And I'll tell you why I'm asking. So a partner of mine has started something called empirical justice. And within the sentencing guidelines, we're always arguing about high end of the range, low end of the range, loss calculation. He has actually started to track statistically what judges actually hand out for that category of offense and those offense characteristics. So we're trying to use those statistics to bring sentencing in line with reality. I would think that something like this, these kind of statistics would also help at the time of sentencing, rather than saying he needs to be in jail for 20 years till he's 65. This shows that you're saying by the time he's 40, there's really no risk. So that's kind of an argument and a question, but the question is, has anybody asked you to supply a declaration or affidavit at sentencing with those type of statistics?
I appreciate that question. We have, I've done some of that to help to present this kind of information at sentencing. More often I'm asked to provide evidence on racial disparities at the time of sentencing. I think that more often the greater willingness and attention that I've seen to second look broadly in prosecutor-initiated resentencing is with the recognition that at the time of sentencing, there's even more reluctance to recognize this evidence. And after a period of time has passed and the person has matured and can deliver themselves and present themselves, show their record during incarceration, that helps to believe that these numbers are real. Once you actually can see how the individual has rehabilitated themselves, like Dwayne was describing, that really helps to make the case better both for prosecutors and judges and for legislators as well. Ideally, we would make improvements at the time of sentencing, but I think that right now there's more appetite to reconsider sentences after some time has passed.
What is the process by which offices who have started doing this has implemented to review the cases to decide which ones to go forward with? Like I heard Dwayne say that if somebody called into the office and suggested a case be reviewed, but how are offices approaching what ones to even look at?
But I can say just a high level, and then you please talk about exactly how it works in San Diego. Typically, in most of the, just broadly in most of the states where we have been supporting their work, the first question is usually around getting their prison data. They want to be able, and most offices have not actually seen their prison data. And so the first is to get their prison data, and we try to support them to get that and analyze it and make it make sense, because sometimes it can be very raw in the data download. And so that's usually the first place, is the elected has decided they want to do this, but they have criteria that they want to use to do so. They want to look at perhaps somebody who is over 65, maybe they were under the age of 18 at the time of their offense, they've been in for 10, 15, 20 years. They're not usually looking at murder, homicide, sex cases, but they want to start with a group that is a manageable size based on what their resources are. So they'll usually look at their prison data, and in some places the prison data will actually show some risk assessment information, whether they're housed at a low-level security facility. So there's information that they can glean from that just to get a starting point. So that's what we have seen, and then typically from that point they'll get a list of names, and then they've kind of been able to narrow and have a reasonable group to start with, and then from there they can look inside to their own case management system, look at the cases and see the conviction is this, but what were the actual facts, and do I still feel comfortable moving forward? So we see a lot of offices, especially larger offices, really start with just their prison data to begin the process.
And that's exactly how we started. And I think one of the things that we did when we did the first case in the state of California resentencing, we had Hillary was present. We had a press conference where we talked about it publicly. As I said earlier, we put a link on our website so that if people want to help family members that are incarcerated, help them through the process, the link will provide them all the documents that we need with releases and things of that nature they can send to us. The other thing that we do now that we've been in this process for a couple of years is we update the community every 6 months with like a press release. And that basically how many people we've resentenced, some of the success stories that we've had. And I think that's our obligation as we do this, to keep and be transparent about what we're doing. But it's part of building the trust with the community. And when they see that we're actually doing this and that we're doing it the right way, we're using a balanced approach, it's part of building that trust that we are trying to build with our community, but also letting people in the public know what we're doing, what's available. And and as I said, we have about 191 applications currently pending in our office now, and we get 10 or 12 a month. And I think also it's spreading. I mean, I think it's helping with programming in our state prisons. People are more likely to take those extra classes, go get back and get their education, because there's a light at the end of the tunnel. And that's what we're hoping that will also be a consequence of this as well.
How many cases have you guys resentenced?
48.
48. Any other questions? Okay, we have 5 minutes left, so I'm going to take advantage of the 5 minutes because I have some questions. I actually wanted to ask you, Dwayne, a bit about the victim notification process. You mentioned the trauma-informed piece, but can you explain how that is happening on the back end? We had heard early on that victim services weren't clear on how exactly to approach victims, because usually they're approaching victims for a different topic, and they really hadn't been equipped with how to do this. So can you talk a little bit about what that's looked like?
Right, so we actually have instead of having a victim advocate reach out to our victim, we actually have our DA reach out to the victim. And that DA is able to answer all the questions about their previous cases, answer their questions about what we're trying to do, what we're trying to accomplish, why we're doing what we're doing, what is the mission of our office, how this fits within the mission of our office, giving people a second chance. And I think that approach has been very successful. And we haven't done any of these resentencings where the victim hasn't agreed to do it. I mean, I think it's part of what our office believes is important, that we have victim buy-in. But in order to get that, you have to make sure you do it in the right way. And that's a process that we use that's been successful for us.
And you mentioned earlier as well about kind of making sure that people knew that this wasn't about a mistake that was made. But can you talk a little bit about, because I remember the judges, right? There's this feeling of this is like an appeal. Oh, great. Amazing. That it was like an appeal coming back, and so it was the different orientation around kind of defenses were up. Can you talk a little bit about what judges have said since you've explained that this isn't about nobody did anything wrong, and what the reception has been?
Right, because the law in the state of California is that you have to present the case for resentencing back to the original sentencing judge. And so when we bring these cases back before those judges at the beginning of this process, right, they were very defensive about it. It's a brand new law. They hadn't been briefed on it thoroughly, and so we had to explain the law to them. And just explain to them what we were doing and why we did. We had to explain the whole process to them from the beginning to the end about how we got to this point. How we are the one petitioning you court to resentence someone. Usually a defense attorney is making that petition to court for consideration. But here we have a prosecutor actually asking the court to resentence someone, and we explain to the judge why we're doing this, and take them through everything that we've done, how we've analyzed this person's history, their experience, how they've changed, what our victim input is. And I think with all of that information, they've become comfortable with the process, and now that we do it, generally they're on board. So we haven't had any case in San Diego County in which we asked the court to resentence someone that the court did not agree to do it, even though they have the discretion to deny it.
Are they happy about being involved in this? I mean, spoiler alert, that's what we hear. We hear judges say, I'm so glad that I have this opportunity to do this. I'm so pleased to hear, because I remember this case 10 years ago, 15 years ago. I never would have thought I would be looking at the same person in this way. That I am shocked that, congratulations, but I am pleasantly surprised to see this, trajectory of change that you've undergone. So I don't know if you've heard those similar things.
I have, and I think initially they are surprised when a prosecutor's bringing it before them, but at the same time I think they're glad that it means that we're actually, sometimes they believe we're doing the right thing, because they would have liked to have done that if they had an opportunity to do it. And so we've heard those kind of comments from them, and I think as prosecutors, we all know, at least we should know, that justice doesn't end for us at the time of sentencing. There are many things we're involved in post-judgment as it relates to justice. And this is just part of that process. And so that's how we've kind of incorporated, how we've sold it internally in our office, because not everybody was on board internally with this, this idea of resentencing people. You know, and I think that this is part of our effort to change some of the hearts and minds of the people that work for us about doing what is right, what is just. And you know, a lot of times, what really gets me, I'll just tell my own personal perspective on this is, you know, someone has done 18 years in prison, they got 32 more years before they're eligible for parole, and they've done all these things to improve their life. Why not give them an opportunity to reintegrate in the community? It just seems to me that we as a system need to do more of that and actually look at what people have been doing, how they've improved their lives, and give them a chance. The first guy that we did, I'm just thinking about it myself, and him having to spend 32 more years in prison when he'd already reached the point where he could reintegrate back into the community and made that progress would have been wasteful as far as our resources, but also hurtful to our community. So.
Right. And I wanted to bring both Frank and Nazgul back in. One of the things that we've recently heard this, is that what kind of data would be helpful in making these kinds of decisions, right? And as all prosecutors know, we don't have a crystal ball on the front end, right? We're looking at rap sheets, we're looking at the underlying offense, we're talking to victims, talking to witnesses. But I think that there is some desire for prosecutors in making these decisions to have a little bit more assurances or something that they can look to be able to make these decisions safely. And so I'm wondering, Frank, what if anything have you heard from prosecutors around, we hear a lot about evidence-based and data-driven and the kinds of things that would be helpful for prosecutors to make these decisions. And then I'd love to ask Nazgul if you just happen to have a research report written on it.
My guess is yes, but it's a great question, and I'll actually pick up where Dwayne's point, where community safety doesn't stop when the arrest happens either. And I think that's been part of the challenge when we talk about community violence and this uptick in violence we're seeing is that, we made the arrest and that. No, that's not how this is solved. So where does that lead? Well, to the question about recidivism.
Right.
And I think prosecutors, and I'm not picking on my members, so they'll say I will, so bear with me. We like to think we're good at making judgment calls when it comes to recidivism, and I think in many ways we are. But we also, in this approach, is so many different layers and factors baked in that we're making sure we're making the choices that are in the best interest of the victim, the best interest of the community. So that recidivism data that I'm sure you and Nazgul or others are collecting is going to be integral to this, because if we can show it's even more successful than other very important reform efforts, the buy-in's only going to continue to increase, and the message to the public is going to continue to increase. Because I think there is the misperception that's growing in this current moment that, once you've made the arrest or the prosecution, that's what's been best for community safety. We've solved the community safety problem. Well, no, you haven't, because a lot of times those individuals, the majority of those times, or 90% are going to get out of prison. And second of all, the folks who don't get out of prison, this is the last piece I'll touch on, because it's intuitive, build the culture in prison. And so if we're making sure we're opening these pathways to everyone from the low level to the more violent offender, and we're doing it in that holistic approach, community safety doesn't end at the arrest, it doesn't end at the prosecution. In many ways, it begins there. And those returning individuals help set the bar for success down the road. So recidivism is a starting point, but it tells a broader story that we have to tell.
Right. Nazgul?
Yeah, these are such great points. I guess my top two variables would be, to look at would be age at the time of the offense and current age, right? So when you look at the age crime curve here and you see that the person committed their offense under the age of 18 as a juvenile, or even under the age of 25, 26 as, late adolescence, emerging adult, that's the period of time that you expect people to be most likely to engage in criminal activity. And they're especially susceptible to rehabilitative services while they're incarcerated. They're especially likely to mature and change over time. And then current age, so if the person is age 40 and beyond, and the older the person gets, the extremely unlikely it becomes that they're going to get into serious trouble again when they're released. So those are two factors I would consider. And then qualitative factors like, who are the people that the wardens are pointing to as the people that create stability in the institution, that are serving as mentors, that are leading and providing programs for others. I mean, they're wonderful individuals within facilities, but because of that, that doesn't mean we should keep them there, right? Those are reasons that they should be able to be released to our communities. We need them to be doing that kind of work in the broader community. And who are the people that have support from victims and survivors, especially once a process has been initiated to update victims and survivors about how the person has transformed over time based on their prison record. And one thing I would just say about the prison record is I think that there's a bit of a concern there that I think that should be applied when looking at the person's record during incarceration, because we know that that record is likely to be affected by racial bias in institutions, and that people of color are more likely to get written up for disciplinary violations, especially when they're younger during their period of incarceration. So I would say that the record is really important, but at the same time it's important to consider, if there were disciplinary violations, when did they happen, how long ago, what was the nature of them, and so just to take it with a bit of grain of salt.
Good, I'm glad, because that's what we do. And we hadn't even talked about this, but no, it's a really good point, because it's exactly one of the things that is happening, is that if a person has been incarcerated for 26 years, it's looking holistically at that whole period of time, because oftentimes in the first 5-6 years, it's what we call a transition period, 18 years old, not looking at a life sentence. And so you see a lot of violations that are happening during that time. And what we have, I should have brought it here, we have graphs too, but we put some graphs together to show the kind of a line graph of the violations that are happening when they first come and are incarcerated, and that they go down over the time that they've served, and then at the same time you see the programming going up, and you see a direct correlation with the programming going up and the violations going down, and you literally see this crossing happening. And so we're able to sort of like zoom out and kind of look at the whole time. We see a transition period with a lot of violations and very little programming. You see another period of time where they're just beginning to identify what the drivers were, what the issues were, start to feel comfortable in taking programs, and then the programming is taking off, and then the violations are obsolete. And so I think that that's really important. And the other thing, this is even for me when we first started, because it was, the data would come in and you would be able to see if a person had picked up violations, how many they picked up. And so at first it was, well, then we shouldn't look at that case because they have 4 violations. But then when we got the files and actually looked at what the violations were, disobeying an order, is stealing state property, on their face they felt very concerning. And then oftentimes we look deeper, and one person in particular was stealing peanut butter. He was making bird food. I can't make these stories up. He was affectionately known as Birdman at San Quentin because he would, and I'm not making this up, he would lure the birds with broken wings, mend their broken wings, and this is literally what he was doing. But on its face, when we saw initially the theft of state property, it told a different story. So, and I think that this is something that is also part of this, was initially the skepticism, because defense attorneys were obviously very reluctant for an entire case file to just be turned over. That is not the way that most defense attorneys practice, right? They want to get the information, they'll summarize what's there, and then they'll present it to the prosecutor. But the way that this has actually worked is that it's open file, let's look at everything. We should know everything that's there. And oftentimes, looking deeper, right, it's the combination of the prosecutor being willing to see the instances, see the violations in context of what might have been going on for that person at a time. That was when their mother passed away. That was why that violation happened. There was a cell phone violation, and that shouldn't have happened, but they were calling their daughter to wish them happy birthday. And so the willingness of prosecutors to contextualize what they're seeing, and then defense attorneys being willing to have this process of, okay, I'm turning everything over and we're just gonna look at everything, the good, the bad, and the hopeful, it is something that has also been really unique in this process. So I'll also pause in it, now that you've heard more of the journey, any other questions based on what you've just heard? Seeing none, okay. I like that it's interactive, which means that you should interact, but that's okay. I know you're taking notes. Okay, I wanna, we only have 5 minutes now, for real. I wanted to close out, which we like to do a lot of times on panels like this. I'd like to ask you each a question about what you are hopeful for with this new emerging area of law. You've seen where it started, you've seen where it is today, and I'm just curious from each of you what you would like to see in the future with prosecutor-initiated resentencing. And I'll start going this way, Frank, Nazgul, and then Dwayne.
Wonderful, and I'll keep it brief, but touch on 2 quick points. One is the success of victims in this. One of the things is, as somebody who's advocated on criminal justice reform for 5 years, that I feel like we fell short on was making sure that victims are treated the same way they are at the front end of the process when they first are found against, and then the back end. And this is one of those efforts that's expanding the way we ensure victims are a part of the process. And then we often find, as you've stated many times, that they want to be a part of this. They want to be a part of the success of that returning individual and of the criminal justice system broader. So that's one. And then 2 is changing this narrative that we're seeing shuffle around community safety. Community safety and public safety is at the top of every prosecutor's mind, and it is something we're proactively working on, but this is part of that solution. And I think as we sell that to the public and to the constituents and to the broader criminal justice system, it's going to impact everybody in a positive way.
Agree.
I agree as well, thank you. Yeah, I think that for me, really I guess the two elements would be reducing the cruelty of the system, where we see people that are incarcerated that can be clearly released, who are in prison in their 60s, 70s, and beyond. But really for me, the priority is public safety and moving the focus away from extreme sentences that are incarcerating these individuals who are no longer posing a public safety risk, and really freeing up space and resources to think about what are the ways that we actually can prevent criminal offending from happening in the future and prevent the kind of trauma that victims are dealing with, and helping victims who are, and survivors who are going through the process of having the person who harmed them be resentenced, providing them with the support and information to heal more than we have been doing in the past, where the case is completed, the person's not getting information about how that individual is changing. And so, for that individual victim and more broadly to prevent that kind of harm from happening in the future.
And I would just say this for my fellow prosecutors out there, to keep an open mind. I think that when if you had an opportunity to look at some of these sentences and go back and look at how much time we're given and how much time they would be given today, and the changes and the improvements that they've made, I think you'd find that a lot of these sentences have been disproportionate to where we are today as a society, and that there are a lot of people that are ready to reintegrate back into the community. And I think that's part of our responsibility as prosecutors. And the second part of this is, I think you can do it balancing public safety with doing what's just. And a lot of times people think we're leaning one way or the other, but I think if you do it in a reasonable, responsible way, you can have success, and I think you can protect your communities and build trust with our communities that we are doing the right thing.
And I will just end on that as well, that I am hopeful that we continue to have these conversations, and we continue to be courageous and thinking out of the box and being a little uncomfortable sometimes in doing something that hasn't been done. And it doesn't, if you're skeptical, stay with the conversation, because maybe beyond that skepticism is really an opportunity to do something different and do something that is going to make us safer and result in more just outcomes. So thank you everybody for staying around for our panel, and hope you have a good rest of the day.